the rest of the week.
In order, Ms. Jack?
No objections, Your Worship.
Sir, your matter is postponed to the 17th of February. Back to this court. It's for the investigating officer to trace.
Good morning, Your Worship.
Good morning. Good morning.
May I proceed?
Yes, are we on record?
Your Worship, the court orderly has just gone to go and fetch them. It will take approximately a minute.
In order.
The State refers the court to case number RC 22 of 2025, State versus Darren Gavin Wilkin and Tiona Megan Moodley. Appearance is held in Randburg Regional Court on the 3rd of February 2025. Presiding officer Mr. Ragnunandan, prosecutor Advocate Ryan, interpreter is not required. The legal representative of accused number 1, Advocate Kriel, as instructed by Botha du Plessis and Kruger attorneys. For accused number 2, it's Mr. Oosthuizen. May I approach the bench, Your Worship?
In order. Thank you. Appearances, can you confirm legal representatives?
As the court please, Your Worship, to confirm that the instructions of the EDK attorneys have been terminated on behalf of the second applicant, Ms. Woodley. My learned colleague can address Your Worship further in that regard.
So you're representing just accused one,
Accused first applicant.
or the first applicant? Yes.
Good morning, Your Worship.
Good morning.
I do confirm my appearance on behalf of accused number 2, Your Worship. I do confirm that I've been mandated to assist her with this matter.
It's
Going
Mr.
forward.
Oosthuizen.
Mr. Oosthuizen, Your Worship, from Van Zyl Johnson Attorneys.
Applicant 1, are they in the correct order, State?
Applicant 1, I'm not sure how the order works in this court. My apologies.
Just
If I
follow the
can
numbering.
Swap around, please. So applicant 1 and 2 is in the correct order.
Applicant 1, do you confirm what the your counsel has said? All right, you need to speak into the record. I cannot. Okay. Applicant 2, do you confirm that you have a new attorney on record? All right. Thank you. Then we may proceed. What is the position of this matter?
Your Worship, we are ready to proceed with the bail application. As the court is aware, on the previous occasion, defence for applicant number 1 indicated that they have an issue regarding the schedule of this application. The State is in possession of written confirmation in terms of section 60 sub 11 paragraph A of Act 51 of 1977. Confirming that this is indeed a Schedule 5 offence. The certificate has been signed by Advocate Arvina Prashad, who is a Deputy Director of Public Prosecution stationed at the Office of DPP, Johannesburg. May I approach the bench for this to be marked as Exhibit A?
You may approach, yes. Certificate then will be marked as Exhibit A, State.
As the court pleases.
As court please, Your Worship.
As it please the court, Your Worship.
Schedule 5 offence.
As court please, Your Worship. Further proceed on behalf of the first applicant, Your Worship, by way of affidavit. May I hand up the regional to Your Worship? I will then proceed to read a copy into the record.
State, any objections?
I have no objection. I
Are we
have been
proceeding with the
placed-
bail application in respect of applicant 1? Are we proceeding now with the bail
Indeed,
application
Your
in
Worship,
respect of Thank you. Thank you. You may proceed only once you've read it into the record and your client has confirmed. Will I then only mark it as an exhibit?
As court please, Your Worship.
Thank you. You may proceed if you're ready.
The regional court for the
My
regional...
apologies, Your Worship, for the interruption. If before the affidavit is read into the record, if the applicant may confirm whether he has been advised of his rights, that he has indeed the right to remain silent before the affidavit is read in the event that there are any admissions made in the bail affidavit, the state that will be using that in the trial proceedings at later stage.
Advocate Creel.
Bishop, I think it will be appropriate. The case was quite clear that such a warning must be repeated by the court, even if I had indeed warned the applicant of such
Sir,
circumstances.
you conversant in English? You fully conversant in English?
Yes, I am.
Did you hear what the state advocate said about the affidavit that you have deposed to, and before it's read into the record? That you have a right to remain silent in respect of your defense or anything that may incriminate you in future? Do you understand that?
Yes, sir.
All right.
As court please, Your Worship. Your Worship, may I be seated?
In order.
Thank you. The Regional Court for the Regional Division of Gauteng held at Randburg, case number RC/22/2025, between Darren Gavin Wilkin, the applicant, and the state respondent. Affidavit in support of bail application. I, the undersigned, Darren Gavin Wilkin, hereby declare under oath as follows. 1. I'm the applicant in the above-mentioned matter, an adult male, aged 34, with the following personal particulars and background. 1.1. My identification number is 900-810-5115-087. Date of birth, I was born on 10 August 1990. Citizenship, I'm a South African citizen. Travel documents, I do have a valid passport, which was confiscated by the police during my arrest. Previous travel and residence in foreign countries, I was born in South Africa and have never resided outside the Republic of South Africa. I previously travelled to Thailand during 2023 and Bali and Thailand during 2024 for holiday purposes together with my partner. Relatives resident outside South Africa. I do not have any relatives outside the Republic of South Africa that I'm aware of. Assets outside the RSA. I do not possess any assets outside the borders of the Republic of South Africa. Personal background, place of birth. I was born in Port Shepstone, KwaZulu-Natal. Schooling, I attended Mid-Rand High School, where I completed the requirements for the National Senior Certificate in grade 12 in 2008. Tertiary, other training, I have no tertiary qualifications. Work history, I started working as a sales representative in Ink for Less in Midrand in 2011 until 2015. Thereafter, I took up employment with Just Letting in Midrand as an estate agent between 2016 and 2020. In 2021, my mother and I started our own estate agency, Pinnacle Property Group, where I also functioned as an estate agent. 2023, Pinnacle Property Group was sold. I further sold my vehicle, a Volkswagen Tiguan, and saved the proceeds to live on whilst my new business in online trading grew. I started an online business selling content from the following websites: Masterypath.live, it's the e-learning courses, Artisphere.top, digital stock images, epixelcreations.com, WordPress, themes and plugins. Masterpath.live closed down during approximately November 2024. From these online trading sites, I earn approximately 50,000 Rand per month. On 25 July 2024, my co-accused sold a motor vehicle to my mother for 125,000 Rand. I withdrew this money in cash, which we kept in the house whilst getting a settlement amount to repay the loan. During November and December 2024, Tiona, Bishop, that is the second applicant in this matter, requested settlement amounts, but we did not get to settle the outstanding loan. The money was still in my possession when I was arrested. On 19 January 2024, my account was frozen by First National Bank due to due diligence, which was apparently not done. I contacted my private banker who should have done this, and the form was completed. I was ever locked out of my account for approximately a week. I decided to open a bank account with Discovery Bank and transferred funds from my F&B account for this purpose during April-May 2024. Discovery Bank does ever not have any physical branches, and I again transferred money back to my F&B account that I withdrew in cash, as I no longer trusted the bank. I could, however, not close the account, as the payments from my websites were deposited into this account. We were looking to purchase a property in Waterford Apartments in Midrand and wanted to use the funds as the deposit for this purpose. General remarks regarding background and permanency. I've been residing in Gauteng Province, Republic of South Africa for the last 20 years. I have strong family and social ties in the Gauteng Province. My mother is the owner of the property situated in Ramsgate, as set out here under. Current status, address. During the period from 2022 to 2023, I resided at Block 20, Unit 3, Rosa Royal Estates, 17th Road, I'm not sure whether that's correct, it might be a spelling error, Your Worship. 17th Road, Midrand, Gauteng, after moving from another property situated in the same complex at Block 18, Unit 1. I'm advised that shortly after my arrest, the landlord terminated the agreement with immediate effect, and Tiana was requested to vacate the premises. If released on bail, I will reside with my mother. Bishop, the address is in there, but as I've stated on previous occasion, there has been intimidation, and I would request that this address not be read into the records with immediate attendance in court.
Well, I'm not sure. Once it's attached to the record, it's a public record, so I'm not sure.
Bishop, even despite the fact it's a public record, Your Worship can still make an order that it should not be shared. There's a real chance, as I stated, that there was immediate termination of the lease agreement, and we do not know what victimization is going to happen to somebody who's actually innocent in this instance. I would request Your Worship make an order that that address not be shared, and that has happened on several occasions prior, Your Worship, in similar situations.
In order, you may proceed. Yes, Saint.
Bishop, maybe my learned colleague can address the state's opinion in that regard as well.
When she,
Thank you,
when
Bishop.
she has the opportunity to do so.
Marital status and general particulars of spouse. I'm unmarried. I've been involved in a stable relationship with my co-accused Tiana Moodley since 2022 and been living together since 2023. Dependents, I have no dependents. Occupation, I'm currently self-employed in online sales. Income from occupation, I earn approximately 50,000 Rand per month from the sales. Other source of income, I do not have any other source of income and relied on the sale of our vehicles to tide us over during the quiet months. Assets, I own a Volkswagen Golf with an approximate value of 50,000 and furniture and household items worth approximately 70,000. I have joint ownership in a property in Umhlanga Sands Resort in Durban, however I do not know the estimated value of this property. Availability and sources of funds for bail. I have an amount of 5,000 Rand available to pay, or can raise an amount that the Honourable Court would find reasonable in my circumstances. Worship, his family had indicated that should Your Worship consider a higher amount, that they will assist in payment of the bail. History of antisocial behaviour. Previous convictions. I have no previous convictions. Pending criminal cases. I have no pending criminal matters, and I'm not on any form of parole, and I'm not aware of any other warrants issued for my arrest. There are no protection orders issued against me in terms of the Domestic Violence Act 116 of 1998 or the Protection from Harassment Act 17 of 2011. So I've discussed this with the applicant as well, and he's aware of the consequences that if he gives false evidence in this regard, that he may be sentenced to a term of direct imprisonment. Arrest and factual background thereto. Date of arrest. I was arrested on 17 January 2025 at my place of residence. The SABC members displayed a warrant for my arrest, and I duly cooperated with them. I've been advised that I will be charged with money laundering due to the cash which was found in my house. I deny that the funds were obtained unlawfully or that I committed the crime of money laundering. As stated here above, the cash that was found in my house was withdrawn from my own account and consists of payments made into my account from the website as set out here and above. 125,000 of this money was paid by my mother for Tiana's car and was be used to settle the finance amount. We utilized this money for daily expenses and would have used the bulk as deposit to purchase property that we were interested in Midrand. Offences charged with. I was informed and charged with the possession of drugs together with accessing, downloading, distribution of child pornography, worship, and then the money laundering as well. Intended plea. I intend to plead not guilty to the charges levelled against me. Defence. I denied all the allegations levelled against me and to reserve the right to respond to whatever allegations the State may make during these bail application proceedings. Submissions regarding factors to be considered when deciding whether bail should be granted. Schedule of Criminal Procedure Act 51 of 1977, the matter resorts under. I've been advised that the offence that I'm being charged with fall within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, Criminal Procedure Act. Consideration terms Section 60, subsection 4A to E. I'm further advised that in considering whether grants an application for bail, the court will consider any relevant factors in Section 64 of the Criminal Procedure Act. Section 64A, danger to the public and individual safety. Particularly submit that my release on bail will not endanger any person's safety. I harbour no resentment against any particular individual or the public in general. Likelihood of evasion of trial. I respectfully submit that this likelihood does not exist in view of my personal profile as set out here and above. I do not wish to evade my trial and live the life of a fugitive, and I do not have the means, financial or otherwise, to live the life of a fugitive. I cannot afford to forfeit any amount that might be set as bail. I undertake to adhere to any bail conditions the court may deem fit to impose, and I'll stand my trial with a view to clearing my name in any alleged wrongdoing. Section 64C, interference with witnesses or evidence. There is no likelihood of me interfering with the witnesses in this matter. I have no access to evidence, evidentiary material held by the investigating officer, and thus have no knowledge as to the identity of prospective witnesses that the state intend to call. In the event that their identities should become known to me, I undertake not to interfere with any of the state witnesses or attempt to intimidate them. Section 64D, jeopardy to the function of the criminal justice system or the bail system. Given all of the above considerations, I submit respectfully that I pose no danger to the function of the criminal justice system or the bail system. I have not furnished any false information for purposes of this application or after my arrest. Except on circumstances, presence or the absence which may lead to undermining public order or peace, I am advised that this section is not applicable to me for the purpose of this bail application. Provision of Section 69, the interest of justice in relation to the right of the release to be released on bail. I respectfully submit that I will be severely prejudiced in the event of being further detained. I also urge this Honourable Court to consider the period I am to be detained until this matter is finalised, and the fact that criminal trials can take a considerable period of time before it is finalised. I also urge this Honourable Court that, should I be detained and refuse bail, that I will be prejudiced in the preparation of my defence. It's extremely difficult to consult with a legal representative inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for trial. Other relevant factors to be considered by the court. Your Worship, there is an alternative address situated at above mentioned, Your Worship. This is indeed the address of his mother where he will reside, should Your Worship consider to release him on bail. In the premise and take into consideration the relevant schedule, the charges resort under, I respectfully submit that the court should grant bail to me in an appropriate amount and with such conditions attached as the court may deem fit. Your Worship, this affidavit was signed and commissioned at court.
On the copy that I have, it's just only one initial on each page.
Excuse me, Your Worship?
On the copy that I have, is just one initial on each page. I assume you've got his initials as well as the Commission of Oaths in your copy?
I just have a look at that, Your Worship. I'm not sure what happened.
It's just one initial here. Which I presume is your client?
Your Worship, that is indeed correct. It was signed. It seemed it was not initialed. May I request the man to stand down
Yes,
and
you
I
need
will
to comply
have it properly
with
commissioned.
yes.
I do apologize
Please
for that,
do
Your
that,
Worship.
and you may, if there's no objection from the state with the address, delete the address part of it.
I will do so, Your Worship. Thank
All
you.
right, matter then stands down for
Thank you,
you
Your
to correct that affidavit before you hand it up to me.
That's good, Your Worship. Thank you.
Okay.
No objection.
All right. How long will you need counsel?
Your Worship, I think in the circumstances it might be easier
Okay, I
to
adjourn.
find the rather than find the court order, maybe just have a new one commissioned with the necessary alterations and then hand it up. It might be quicker.
Would you want me to
Maybe
adjourn?
some 10 minutes, Your Worship.
All right, then is that in order, Steve? Can we take a short adjournment or for about 10 minutes?
Then we will return at 12.
Can I return at 12 or will you?
Yes, Your Worship. I'm quite sure it will be sufficient.
Very well, then court will take a short adjournment. Court adjourns?
Please, Your Worship. Your Worship, I have indeed used the copy that I read into the record. There are two alterations. The first is copy right at the top of my handwriting, the handwriting that was deleted, and the last paragraph under other relevant factors to be considered by the court with the alternative address was deleted as well. It was signed and commissioned today and commissioned with the assistance of the court order, Your Worship. May I hand up
Thank
the
you.
affidavits?
It's marked as Exhibit B. Mr.
Please,
Mr.
Your Worship, that's in the case for the applicant.
Just a second before you close the case. Mr. Wilkins, do you confirm the contents of this affidavit? Did you sign it?
Yes.
And did you sign it freely and voluntarily? Thank you. Exhibit B. You were saying? Is that your case?
That is the case for the applicant, Your Worship.
Thank you. State. Are we proceeding with your application
Yes, Your Worship. We are ready.
in respect of applicant 2?
Your Worship, I'll just ask that the accused be sat down again. Your Worship, may I beg leave to hand up the affidavit?
Proceed. Thank you. Okay, before you proceed, applicant 2, please stand up. All right, you have an attorney here on record, and you are aware that of the contents of the affidavit and anything you say in this affidavit that incriminates you could be used against you. Do you understand that? All right. Anything further? It's Mr. Oosthuizen.
Yes, Your Worship.
Anything further you want me to explain to your client, or have you
None, Your Worship. I did consult with my client. I've explained everything to her in terms of her rights, Your Worship.
the right to remain silent as
Yes,
well?
Your Worship.
You understand that, ma'am? All right. Thank you. You may proceed if you're ready.
Thank you, Your Worship. In the Regional Court for the Regional Division of Gauteng held at Randburg, the applicant is Diona Megan Mootley versus the State. Affidavit in support of the bail application. I, the undersigned Diona Megan Mootley, hereby declare under oath as follows. The applicant in the above-mentioned matter, an adult female, age 25, with the following further particulars. My identification number is 99110903120082. Date of birth, I was born on the 9th of November 1999. I am a South African citizen. I do possess a South African passport. I do not have residency in any foreign countries. I do not have any relatives residing outside of South Africa. I do not own any relatives outside of the Republic of South Africa. My personal background, place of birth, I was born in Durban, KwaZulu-Natal. My schooling, I went to school at Mirabank Secondary School, where I completed my matric in 2018. Tertiary and other training, I started studying finance at IE's School of Engineering. However, I did not complete the course. While studying, I was employed as a part-time at a real estate agency named Ida Property, where I performed administrative works. My work history, in 2021 I was employed at Makru and conducted online sales as a customer service representative. I was then employed by Unlimited Field Marketing Services between 2019 and 2024, where I was employed as an administrative assistant. I resigned from Unlimited Field Marketing Services in February 2024. General remarks regarding the background and permanency. I'm a permanent resident in South Africa. I grew up in Durban and then moved to Johannesburg. I do not have any plans and or desire to relocate elsewhere. I do not intend to reside outside of the Republic of South Africa, as I consider it to be my permanent home. Your Worship, my current status, I'm currently residing. Your Worship, if I also may beg that I do not read in the address into the record, Your Worship. I do know the copy that I gave you, Your Worship. I did not black out the address as yet. I will tend to do so.
You can
Your Worship, I can also confirm that this address has been verified by the investigating officer. The marital status and general particulars of the spouse. I'm currently single and I've never been married before. Dependents, I do not have any children or any other dependents. Occupation, I'm currently unemployed. Income from occupation, I do not own any income at the moment as I resigned from my previous employer and was reliant upon accused number 1 to fund myself. Other sources of income, my family and friends will support me financially and emotionally during the proceedings in this matter. Assets, I do not own any assets. Availability and source of funds for bail, I can afford to pay bail in a reasonable amount of 5,000 Rand, which is readily available. My friends and family will pay this bail on my behalf. History of antisocial behavior, previous convictions, I do not have any previous convictions. Pending criminal cases, I do not have any pending criminal cases or warrants of arrest against me. The penalty clause, my legal representative has explained the said clause to me and I do understand same. Arrest and factual background there too. On the 23rd of January 2025, I was contacted by the investigating officer regarding my arrest. I willingly made myself available at BDK attorneys for the arrest, demonstrating that I had no intention of evading the process or avoiding the trial. Throughout this matter, I've consistently cooperated with the South African Police Services. The offences that I'm charged with, I'm informed that I'm charged with the possession and distribution of child pornography, as well as money laundering. I intend to plead not guilty. The defence, I've been informed of my right to remain silent at this stage and not disclose the basis of my defence, which right I wish to exercise. Safe to deny all the allegations levelled against me and to reserve the right to respond to whatever allegations the state may make during these bail application proceedings. The submissions regarding factors to be considered when deciding whether bail should be granted. Schedule of the Criminal Procedure Act 51 of 1977, the matter resorts under. I've been advised that I'm charged with being in contravention of the following: Section 19 of the Films Publications Act 65 of 1999 for possession and distribution of child pornography, Section 4, 5 and 6 of the Proceeds of Crime Act, Section 20, Subsection 2 of the Sexual Offences and Related Matters Act for benefiting from the proceeds of child pornography. I'm further advised that in considering whether to grant an application for bail, the court will consider the relevant factors listed in Section 60 of the Criminal Procedure Act. Considerations in terms of Section 64, subsection A to subsection E. Section 64, subsection A, danger to public or individual safety. I respectfully submit that my release on bail will not endanger any person's safety. I do not have any disposition to violence and harbour no resentment against any particular individual or the public in general. I do not pose any danger to any particular individual or the community. I will stand my trial with a view to clearing my name of any alleged wrongdoing. Despite the public media attention, I respectfully submit that I have not received any threats, nor do I believe that I will receive any meaningful threats in the future. Section 64, subsection 4, subsection B, the likelihood of evasion of trial. Due to the above, I respectfully submit that this likelihood does not exist. Given my belief that I'm innocent of what I'm being accused of, I do not wish to evade my trial and live the life of a fugitive, and I do not have the knowledge, financial or otherwise, to live the life of a fugitive. Since the date of the first accused arrest on 17 January 2025, I've been providing the SABC with my full cooperation and even arranged to hand myself over to the SABC upon their first request for me to do so. At no point in time did I attempt to in any way avoid and or delay my arrest. I've been completely cooperative with the investigating officer in the matter and will remain to do so in the interest of justice. I will stand my trial with a view to clearing my name of any alleged wrongdoing. The interference with witnesses or evidence, Section 60, subsection 4, subsection 6, C, apologies. There's no likelihood of me interfering with the witnesses in this matter. I undertake not to interfere with any of the state witnesses, even if their identities became known to me. I have no access to evidentiary material held by the investigating officer. I will also not interfere with the investigating of the case if I'm granted bail. I specifically undertake that I will not access any and or platforms that contains any materials that may be utilized in any trial regarding myself and or the first accused. In any event, the MPA or investigating officer or investigating authorities would be able to detect if I contravene such an undertaking. Section 60, subsection 4, subsection D, the jeopardy to function of a criminal justice system or bail system. Given all the above considerations, I submit respectfully that I pose no danger to the functioning of the criminal justice system or the bail system. I've not furnished any false information for purposes of this application or after my arrest. Section 60, subsection 4, subsection E, the exceptional circumstances which may lead to the undermining of public order or peace. I respectfully submit that there are no exceptional circumstances which may lead to undermining public order or peace, should the court decide to grant me bail in this matter. I'm aware of the fact that this case has gained wide media coverage. However, this should not impact my right to not be detained until being proven guilty of the above-mentioned charges. It has been widely reported that there are alleged some 10 million images that will be utilized in trial. Whilst I have no knowledge of this and do not understand how such a quantum was obtained, it is quite apparent that any trial would be of a considerable length, probably extending into years. Accordingly, the refusal of my bail would lead to me being incarcerated for an extended period of time without being found guilty of any offence. The provisions of Section 60, subsection 9, the interest of justice in relation to the right to be released on bail. I respectfully submit that I will be prejudiced in the event of being further detained, in that conditions in prison are most appalling. In this regard, I request the Honourable Court to take into account my period of incarceration of a period of 11 days to date, as well as the aforementioned factors. Other relevant factors to be considered by the Court, I respectfully submit that the interest of justice permit my release on bail, and that I'm therefore entitled to be admitted to bail. I submit further that I'm not a flight risk. I'm willing to abide by any condition the Court may deem fit to impose, including but not limited to frequent reporting to the SABC. I once again accept the advice from my legal representative and respectfully submit that the State has not proved this to this Honourable Court that it will be in the interest of justice to keep me in custody pending finalisation of my case. In the premise and taking into consideration the relevant schedule, the charges resort under, I respectfully submit that the Court should grant me bail in an appropriate amount of R5,000 and with such conditions attached as the Court may deem fit. Signed by the applicant, Your Worship, Randburg, on this day, and same is duly commissioned. That is the case for the second applicant, Your Worship.
Applicant 2, Sarah, do you confirm the contents of this affidavit? Have you signed it? And you did so freely and voluntarily? All right. It will be marked as an exhibit.
It will be Exhibit B, Your Worship.
Exhibit C. Thank you.
As please the Court, Your Worship.
State.
Your Worship, the investigating officer has drafted an affidavit. However, the Commissioner of Oaths is in the SPP's office. They are just busy initialing each page. Shall I proceed to read the affidavit into the record? I am able to give the Court the unsigned copy until he returns.
There's the affidavits there. You may block out the addresses here if you want, if you wish to.
Apologies, Your Worship.
You may.
The affidavits for you to block out the addresses.
Please.
Advocate Priela also handed you your one. I see you've just deleted it, but you can block it out.
That's good.
Shall I proceed in that fashion? As soon as the investigating officer returns, Your Worship, I will hand the Court the original. This is just for purposes of following.
Are we ready?
Yes. I, the undersigned, Hendrikus Johannes Boshoff, hereby state under oath in English as follows. I'm a warrant officer in the South African Police Service with personnel number 04405-463 and stationed at Gauteng, FCS Serial and Electronic Crime Investigations Unit, 176 Smith Street, Braamfontein, with cell number 071-185-4130, email address boshoff@saps.gov.za. I'm the investigating officer of Midrand Cas 107/01 of 2025. 3. The applicant in this matter is charged with the following offences. 1. Contravention of Section 19, capital A, sub 4, paragraph A, distribution of child pornography. 2. Contravention of Section 19, capital A, sub 4, paragraph B, making available child pornography. 3. Contravention of Section 19, capital A, sub 4, paragraph C, transmitting child pornography. 4. Contravention of Section 19, capital A, sub 4, paragraph D, offering for sale of child pornography. 5. Contravention of Section 19, capital A, sub 4, paragraph E, selling child pornography. Contravention of Section 19, capital A, sub 4, paragraph F, procuring child pornography. 7. Contravention of Section 19, capital A, sub 4, paragraph H, accessing child pornography. 8. Contravention of Section 19, capital A, sub 4I, downloading of child pornography. Contravention of Section 19, capital A, sub 3, paragraph A, possession of child pornography. 10. Contravention of Section 20, subsection 2, using children for or benefiting from child pornography. Your Worship, that is all in terms of Act 32 of 2007, the Sexual Offences and Related Matters Amendment Act. 11. Contravention of Section 4 of Act 121 of 1998, money laundering. 12. Contravention of Section 5 of Act 121 of 1998, assisting another to benefit from proceeds of unlawful activities. 13. Contravention of Section 6 of Act 121 of 1998, acquisition, possession or use of proceeds of unlawful activities. 14. Contravention of Section 4 of the Drug and Drug Trafficking Act 140 of 1992, possession and use of drugs. 15. Fraud. And 16. Contravention of Section 36 of the General Law Amendment Act 62 of 1955, possession of stolen property. 4. The matter resorts under Schedule 5 for the purposes of this bail application. 5. The facts of this matter are briefly as follows. A so-called sextortion matter was reported by an underage girl in the United States of America, hereinafter referred to as the USA. The sextortion matter was investigated and reported to the Federal Bureau of Investigations. The investigations led the FBI to a website called Dunk Megas. The investigation led to applicant 1 being identified as the administrator of this website. The investigations were conducted by the United States Law Enforcement, FBI Washington, U.S. Embassy Cyber Task Force. They found that the administrator of the website was a perpetrator who was hosting his own pornography website containing both adult and child pornography. 7. Several purchases of child abuse material or child pornography was made from the administrator of the said website. Applicant 1 is the administrator and owner of the website. During the investigation, several undercover purchases were made by the undercover agent from the website. Purchasing content contained child pornography. Name of content, price and content. State wins massive, price 1,892 Rand. The content of this was CSAM. Your Worship, for clarity, that is child sexual abuse material. Snapcard V1, 93 Rand, CSAM. Snapcard full collection, 6,605 Rand, content CSAM. On the said website listed under Our Spicy Gallery, several photographs were found of naked, very young children, as well as those of young teenage girls, of which the images were up for sale once the website was accessed. At the time of the investigation by the FBI, the website was in total size 396.64 gigabytes and contained 1,136 folders and 146,938 files, all containing explicit images of child sexual abuse material. The perpetrator introduced himself to the users as Gavin Wilkin. At the time of the arrest, the images retrieved were well exceeded 39 terabytes. The stock of the applicants increased substantially. Further investigation found securitized identity records of the perpetrator on Google Records, linking the watermark on the email used by them to dunkmegas@gmail.com and dazvilken@gmail.com. This was also linked to an email address of a business in South Africa, admin@pinnacleproperty.co.za. admin@pinnacleproperty.co.za. It is noteworthy that applicant's one's mother was a director at Pinnacle Property. This company was, however, liquidated during 2024. a copy of his South African identity document linked to the last email address. 12. Applicant 1 indicates that he left Just Letting to work for his mother. Applicant 1 was the topic of community outrage after he posted a comment of raping Indian woman on a social media platform. The heading of the new article was as follows: Gauteng real estate agent Darren Wilken roasted for commenting on social media about raping Indian woman, 12 April 2016. And I quote, his employer Just Property in Midrand announced on Facebook last week that Wilken no longer worked for them during that period. We at Just Letting Property Midrand understand the hurt that the public is feeling, and after following the required labour relations process, we can confirm that Darren Wilken no longer works for Just Property. The post was reported about the widespread anger and calls for Wilken to be charged criminally or hauled before the Equality Court and the SA Human Rights Commission after a question was posed on the social group Dark Humour Memes, asking if crime was legal for 12 hours, what would you do? To this, Wilken wrote, I will go rape every Indian woman I see. Then after the 12 hours, I'll hit them up with a message like, last night was fun. We should do it again sometime. Unquote. 13. Due to the fact that the owner and administrator of the website was a South African national, the matter was reported to the SABC. SABC then continued with the investigations. 15. It is to be noted that it is extremely difficult to trace and investigate persons selling and or trading in child abuse material due to limited resources and the anonymity of the perpetrators who hide behind a screen. The assistance of international agencies is therefore vital for the successful arrest and prosecutions of said persons. Applicant 1 was quite difficult to trace. 5 addresses were visited by the investigating officer. 4 of the 5 addresses were false addresses, and only the 5th address was confirmed where the applicant was residing at the time of his arrest. The addresses visited was where the applicants conducted their business, and it was also the residence of the applicants. 19. It was during further investigations that it became apparent that applicant 2 played a major role in the daily running of the business. 20. Her electronic devices were seized where it was clear that there was an attempt to destroy evidence relating to the conducting of their business during the time after the arrest of applicant 1 and her arrest. Fortunately, the said evidence was already secured on a different device and was retrieved. This unbeknown to applicant 2. It is evident that she already attempted to destroy evidence in a ploy to minimize her role in the business. 21. Subsequent to the arrest of applicant 1, the applicants were evicted from the property as a result of the outrage of the community. 22. I was contacted by the applicant's legal representative and supplied with an alternative address for the applicants. These addresses have been verified. Applicant 1 is the owner of 3 motor vehicles. These are blue BMW with registration number KIDS NA GP, a Volkswagen Golf with registration number XFC 815 GP, and a Nissan MP200 with registration number HX76SMGP. This is noteworthy as his business is selling images of children being sexually assaulted and abused online, and his registration number includes the words kids. 24. Applicant 2 is the registered owner of a Suzuki Swift with registration number KG83ZD GP, despite her allegedly selling the vehicle to applicant's 1 mother during July of 2024. Your Worship, the next sentence in the affidavit is incorrect and we request it to be deleted. The vehicle was not found at the scene of the offence. 25. Section 60 sub 1, paragraph A of the Criminal Procedure Act 51 of 1977 states as follows. An accused who is in custody in respect of an offence shall, subject to the provisions of section 50 subsection 6, be entitled to be released on bail at any stage preceding his or her conviction in respect of such offence, if the court is satisfied that the interests of justice so permit. 26. Section 60 sub 4 further states as follows. The interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. A. where there is a likelihood that the accused, if he or she were released on bail, will endanger the safety of the public and any person against whom the offence in question was allegedly committed, or any other particular person, or will commit a Schedule 1 offence. B. Where there is the likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Or C. Where there is the likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses, or to conceal or destroy evidence. Or D. Where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. Or E. Where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. 27. Section 60 subsection 11 of the Criminal Procedure Act determines as follows. Notwithstanding any provision of this Act, where an accused is charged with an offence referred to, paragraph B, in Schedule 5, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interests of justice permit his or her release. 28. The interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. A. Where there is the likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offence. 1. The applicants have no previous conviction. This is, however, not relevant to the charges that they are currently facing. This is indicative of the fact that they are masters at hiding their criminal activities. 2. During the arrest of applicant 1, he was callous enough to indicate that if he is released on bail, he will conduct his business as he has. 2. The prevalence of the particular type of offence is well known. 1. The offence of possession of child pornography is rife in the country and in the jurisdiction of the above Honourable Court. I quote, "The use of children as subjects of pornographic material is very harmful to both the children and the society as a whole. Further observed that child pornography generates a set of harms distinct from those generated by pornographic depictions of adults. As it was put in De Reuk versus Director of Public Prosecutions, Witwatersrand Local Division and others 2003, ZACC 19, 2004, 1 SA 406 CC paragraph 61-2. And I quote, "The purpose of the legislation is to curb child pornography, which is seen as an evil in all democratic societies. Child pornography is universally condemned for good reason. It strikes at the dignity of children. It is harmful to children who are used in its production, and it is potentially harmful because of the attitude to child sex that it fosters and the use to which it can be put in grooming children to engage in sexual conduct, abuse of children. It is generally accepted that children are the most vulnerable members of society, and crimes perpetrated against them are usually highly disturbing and lead to heightened outrage in societies where they are committed. Specific legislation has been passed for the protection of children. But despite progressive children's rights legislation in line with international conventions, the crimes against children seem to remain alarmingly high. The offence of money laundering is similarly extremely prevalent in the court's jurisdiction. The sentence that it attracts is a minimum of 15 years imprisonment for a first offender per count. It is respectfully submitted that these offences are integrated into a criminal enterprise. The one cannot exist without the other. Further investigations in Section 205's supply to First National Bank revealed the following transactional activity that is of interest for applicant 1. Applicant 1 is currently unemployed, yet his FNB Premier current account with number 624061036648 has the following monthly credit turnover of credit received into the account. Your Worship, does the court require me to read these amounts out?
For the record, yes.
As the court pleases. January 2023, 132,192 rand and 58 cents. February 2023, 83,600. March 2023, 171,100. April 2023, 1,310 rand and 33 cents. May 2023, 27,533 rand and 15 cents. June 2023, 137,411 rand and 37 cents. July 2023, 244,592 rand and 71 cents. August 2023, 477,202 cents. September 2023, 459,087 rand and 62 cents. October 2023, 363,528 rand and 45 cents. November 2023, 170,842 rand and 54 cents. December 2023, 269,696 rand and 33 cents. January 2024, 234,787 rand and 94 cents. February 2024, 102,913 rand and 87 cents. March 2024, 101,250 rand and 14 cents. April 2024, 157,338 rand and 58 cents. May of 2024, 127,138 rand and 40 cents. June of 2024, 350,229 rand and 96 cents. July of 2024, 293,989 rand and 46 cents. August of 2024, 385,211 rand and 7 cents. September 2024, 117,816 rand and 37 cents. October 2024, 166,637 rand and 52 cents. November of 2024, 137,367 rand and 81 cents. December of 2024, 234,563 rand and 36 cents. No fixed income is received into this account. As evident from the above credit turnover, his monthly income fluctuates. For the year 2023, his annual turnover in FNB Premier current account was 2,538,095 rand and 10 cents. According to the above, the applicant is facing a minimum of 24 counts. The applicants, my apologies, are facing a minimum of 24 counts of money laundering, which carries a minimum sentence of 15 years per count. For the period of September 2024 and January 2024, FNB Premier current account received a total income of 778,609 rand and 21 cents. The sources of income in respect of the total amount for this period can be summarized as follows. For the period September 2024 and January 2024, for the period between September 2024 and January 2024, FNB Premier current account received the amount of 573,964 rand and 56 cents, which is derived from an unknown source, possible cryptocurrency. For the period between September 2024 and January 2024, my apologies, I was rereading the same paragraph, I apologize. For the period between September 2024 and January 2025, applicant 1 made e-wallet payments to the total amount of 37,800 nearly on a weekly basis to cell number 0719877296. Between 30th of December 2024 and 16 January 2025, applicant 1 and applicant 2 visited Phuket, Thailand and incurred expenses for the total amount of 130,842 rand and 10 cents. On 17 January 2025, the applicant transferred a total amount of $198,500 to F&B account number 62755795021, which is held in the name of Tiona Megan Moodley, who is applicant number 2. The applicant further has financial links with Pinnacle Property Group, of which his mother is a director. This is for the same person who has now supplied an alternative address. Several transactions occurred between the F&B account of Pinnacle Property Group and the applicant's personal First National Bank account during 2023. Applicant 1 further has accounts at ABSA, Bidvest, Luno, Capitec, Discovery and Netbank. Investigations are continuing into these accounts. 39 virtual cards are linked to his First National Bank account. Applicant 2 holds accounts with the following financial institutions: First National Bank, ABSA, Discovery and Netbank. These accounts are under investigation. F&B Premier Current Account is applicant 2's transactional account held with F&B, opened on the 27th of March 2018 and is in an active status. The annual credit turnover for 2023 was R420,955.52. The annual credit turnover for 2024 was R1,254,029.58. This is a 198% increase from 2023. The monthly credit turnover in F&B Premier Current Account for the period between February 2023 and January 2025 fluctuates as shown below. February 2023, R24,768.75. March 2023, R23,991.25. April 2023, R19,025.47. May 2023, R21,926.25. June of 2023, R34,526. July 2023, R63,444.95. August 2023, R59,106.25. September 2023, R49,576.89. October 2023, R24,586.25. November 2023, my apologies, R25,744. December of 2023, R48,042.62. January 2024, R26,260.40. February 2024, R58,071.22. March of 2023, R51,465.37. My worship, if I might just have a moment.
You may.
April of 2024, R69,570.17. May of 2024, R199,401.67. June 2024, R139,864.83. July of 2024, R23,941.91. August of 2024, R136,880. Now, the September 2024, R33,040. October of 2024, R20,644.41. November of 2024, R18,300. And December of 2024, R20,450. The main source of income in the account are D. Wilkins account, Moodley's credit card account, SnapScan and Zapper payments. Once several SnapScan and Zapper payments were received, applicant 2 transfers the funds to applicant's 1 account. In addition, during June of 2024, several payments were received into applicant's 2's check account with the description from Tiona Megan Moodley, even though the account from which the payment is made is not linked to applicant 2 at all. After receiving the payment, applicant 2 transfers the funds then to applicant 1's account. Applicants 1 F&B Premier Current Account and F&B Credit Card are used to pay for several online services. eVoxed, it's a virtual machine in cloud to run applications. Cloudflare, which is a type of a firewall or a security protection for cloud services and websites. 10web.io, which is an AI platform to build, host and scale websites. Blesk, which is a web ops hosting. Attack Technology, it's a domain registration service. Paystack helps businesses in Africa get paid by anyone, anywhere in the world. Hostinger, this is a website builder and hosting. Paddle.net, payment infrastructure that helps software companies manage payment subscriptions and taxes. Google One, which is a subscription service that provides additional storage space for Google Drive, Gmail, and Google Photos. Applicant One's credit card was used for 7 payments to Google G Suite with reference Dunk Mega between July 2024 and November of 2024. From the 19th of March 2024 to 17 May 2024, a trend was noticed that after credits were received into applicants 2's F&B Premier Current Account via Zapper or Netcash. Zapper is a mobile payment app using Netcash Payment Gateway. A rounded off amount would be transferred to Wilkins' Discovery account with number 16830063000. From the 23rd of May 2024 to 7 August 2024, a similar trend was noticed that after several credits were received into applicants 2's F&B Premier Current Account via SnapScan, which is a contactless payment app for online payments, a rounded off amount would be transferred to Wilkins' F&B account with the reference Skills Up Life. According to the Credit Bureau, applicant 2 is the sole director of Skills Up Click Pty Ltd. Skills Up holds an F&B Gold business account that was opened on the 27th of February 2024 and closed on the 7th of September 2024. The income in the Skills Up account is mainly derived from applicant 2's check account. The funds are then transferred out of the Skills Up account to applicant 2's Discovery account with description Skills Up Life. The applicant also has approximately 34 virtual cards linked to her F&B account. 2 of these cards are named Dunk Megas. The name of the site literally translates to Thank You Megas. Applicant 2 is Tiona Megan. The following file's metadata shows applicant 2 as both the creator of this file as well as the last modified. This Excel file contains the names of listed pornography packages that can be bought, to include pricing. The packages were named Banned TikToks, in inverted commas, Rape, and Pedomom, etc. Your Worship, I'm not sure whether I should read that into the record, or shall I attempt? For clarity's sake, this is the packages that were available for sale. For example, we had social event with guest speaker, banned TikToks, 936 Rand. We had basic social package, Lizzie Snapguard bestseller, 560 Rand. Webinar with breakfast sessions, 27 Scat Girls collection. Then we had multi-day workshop, Pedo Mom, 1,873, and the list goes on. WhatsApp messages contained on the laptop used by applicant 2 includes conversations between herself and applicant 1. These conversations include the exchange of specific identifiers like crypto wallets, passwords for the website in question named Dunk Megas. The following screenshots in no specific order. The defense has been placed in possession of copies of these screenshots. I will highlight the message that the state is referring to. The WhatsApp message sent from applicant 2 to applicant 1 is start@dunkmegas, HUB, OBOT first. Go to VIP features and click redeem button. Use redeem and code below. And then it gives a code. Go to my bot list and click on VIP bot start button. All set. And then there's further images. On the 24th of July 2024, applicant sends applicant number 2 sends applicant number 1 78547 name, surname. When this group nukes, where will you find the new link? And then she says https:// dunkmega.me pigeon KMS. I should have finished high school. Must I order something for you? Monthly payment, credit card, check account, 5,200. On page 16, again, I think it is a duplication of the same image. And then on the 19th of May 2024, again, website details sent, https://mega.nz /folder, and then it gives the details of a folder. Then applicant number 2 says to applicant number 1, remind me to redo dunkmega.mc redirection when I'm out of the bath. Okay. And then there's another screenshot attached. Where there is the likelihood that the accused, if he or she released on bail, will attempt to evade his or her trial. The applicants are facing a minimum of period of 5 years imprisonment for each image and each video depicting child abuse images that they had in their possession. It is to be noted that more than 10 million images and videos has been counted thus far. The sentence that the state will be seeking is therefore long-term incarceration. This in itself creates a very attractive incentive to evade trial. As stated, it was difficult to trace applicant 1 in South Africa because of limited resources. Had it not been for the arrest of applicant 1 and the investigations that followed, applicant 2 would have been completely overlooked. 5 addresses was visited by the investigating officer. According to their social media accounts, they frequently traveled abroad to countries like Thailand, Bali, and other destinations where trafficking in children is rife. The applicant has the financial resources to evade their trial. This is evident from the fact that 647,300 rand cash was found in their premises. This excludes funds in bank cards that was found on the premises that does not belong to them. The applicants are also using cryptocurrency, Luno and Bitcoin accounts to which we currently do not have access and has not been blocked. The state has a very strong case against the applicants. There is an abundance of evidence in favor of a conviction. Bail conditions are not always enforceable and cannot be relied on as a means of securing the attendance of the applicants at court. C. Where there is the likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. The applicants are either self-trained IT specialists or has received training. The applicants makes a huge amount of money from the child abuse images. It is therefore in their best interest to have it stored not only on the exhibits that were found, but in alternative storages or in cloud accounts that has not been discovered. They are able to destroy or conceal any evidence that the state has not confiscated. The state was only able to confiscate the exhibits found on the scene. Applicant 2 has already attempted to destroy evidence. They simply need a device that is able to link them to the internet to destroy what we are still investigating and finding. They further only need a device that links them to cyberspace to retrieve any cyber currency that the state has not managed to confiscate or block due to the investigations not being completed. D. Where there is the likelihood that the accused, if he or she released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. South African Police Services has received information that there are no less than 3 countries that has made inquiries into the possible extradition of the applicants. This will definitely not be the end of the countries inquiring into the extradition of the applicants as they committed these offences internationally. E. Where in exceptional circumstances there is the likelihood that the release of accused will disturb the public order or undermine the public peace or security. As stated, there has been an outcry from the community to release applicant 1 specifically into the custody of the community for him to be dealt with by them. His release on bail will not only be detrimental to the proper functioning of the justice system, but will reflect that persons, such as the applicants, who makes a very lucrative livelihood from the distribution, etc., of child abuse images, are not seen as disturbing the public order, peace or security. The applicants has no fixed address. Both of them has given alternative addresses to verify. This is not their property, and they have no ties to this. Applicant 2 has given an alternative address to verify, and I was then told that the family members who would have given her a place to stay did not feel comfortable and or safe with her residing there, and a second alternative address was then supplied. There is absolutely nothing tying them to the addresses that has been supplied. They will not be traceable if they evade. It is evident that a lot of arrests will follow from their arrests and the investigations that are conducted. They have a network of people willing and able to assist them in evading arrest in order to avoid prosecution themselves. Offences of these types are extremely difficult to investigate and bring before court. The applicants hide behind a screen and is able to do so effectively anywhere in the world. They are the unseen predators. If it had not been for the assistance of the USA in collaboration with the SABC, the applicants could and would have remained unseen predators for a very long time. They were conducting a thriving business off of the sale of child abuse material and has been living a lavish lifestyle from the abuse of children. The court is the upper guardian of children and has a duty to protect all children from predators. The state has a strong case against the applicant. In State v. Matibula, 2010, Volume 1, SACR 55 SCA at paragraph 12, the court stated that if an accused person challenges the strength of the state's case against him in the bail proceedings, then in that event, the challenge attracts a burden of proof to show that there is a real likelihood that he will be acquitted at trial. 34. In Schedule 5 bail applications, the court is enjoined by virtue of legislation to order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interest of justice permits his or her release. The legislature considered it necessary to burden the accused with an onus in Schedule 6 and Schedule 5 cases, and hence the question is very simple. Did the appellant succeed in discharging the onus? It is respectfully submitted that the answer is no. The appellants failed in discharging the onus. It is therefore respectfully submitted that the applicant's bail should be refused. Your Worship, the document is signed and commissioned. If this may be marked as Exhibit D, that will then be the state's case.
Are you ready for arguments?
Yes, please, Your Worship. May I request a short adjournment? We need to take instructions on allegations relating to the affidavits that were not in our possession, were given to us prior to actually appearing in court today.
Short adjournment? How long would you need? It's 1 o'clock.
We should maybe adjourn after lunch. I think that would be sufficient time. It's a lengthy affidavit that we need to go through.
Will 2 o'clock suffice, Counsel? 2 o'clock?
2 o'clock, thank you, Worship.
Is it right? Very well. Court will take the lunch adjournment. We'll resume. You want me to do it now? Sorry. You are excused. The prosecutor just has some matters for me to do, so whoever needs to be excused, you are excused. I'm going to continue with other matters.
As the court please.
Thank you.
Thank you.
Ja, ons eigenlijk het hier. Ons is in de context woensdag nog een beetje. Ons zijn een koffiemachine. De koffiemachine kat is het niet stil. Als ik kat blijkt bij de koffiemachine. Niemand luistert. Zij is werkelijk koffiemachine. Dat is hem ook zo. Ja, ik ben you know, it's very lazy stuff. You're all going to be fun. Wait, I'm going to tell you.
That's very funny. Remember, we use litigation. We not use it. And try to please everybody.
I'm not in the media is going to be sensational. The media will hold out the very short
That's the idea.
Hear what?
You see? Verbal diarrhea was all the
You've got the new species smooth. That one was SMOOFA. That's smooth. They praten van religies is smooth. Ja, smooth. Met 'n dubbelpunt. Groot letters is dit. Now, if I had my say, we will finish this last 2 weeks ago. No, but the court said no. We must first find out whether he stole the money or whether it's money laundering.
No, I said it's
No, not you. Your colleague before you. They didn't know why it was money laundering.
Look at mine first. Well, she was
You didn't know why it was money laundering.
Excuse me, I exactly what going on this week. You can't tell me. Weet jy het 'n long debate gehad.
Sien, daarom kom jy nou op yes af. Hulle het gesê, kom ons stel dit so. Ek is miskien gelyk op wat ek doen. Ek dink voor die kom on hier. Hulle wil al
Darren Wilkin and Fiona Moodley. Your Worship, we are back on record. I believe the defence wishes to address the court.
As well, please, Your Worship. Your Worship, on behalf of the first applicant, I have taken up several matters with him that originated from the affidavit by my learned colleague. I cannot do it justice by merely addressing Your Worship. I need to request a postponement so that I can fully ventilate it in the papers and answer to the allegations by my learned colleague, Your Worship. That application for the first applicant, therefore, is that the matter be postponed in order to file answering affidavits or responding affidavits, and I will make them available to my learned colleague as well, so hopefully we can avoid any further postponements.
How long would you need counsel?
I've provisionally discussed with my learned colleague, and basically our first available day is this coming Friday. That'll be more than sufficient. Tomorrow and Thursday we cannot do it, so the week up until Friday we are not available. So Friday is the first available date that we can actually fit it in. After that, my learned colleague is not available. So if we can do it this week sometime, I will make arrangements to make myself available if another date is more suitable to Your Worship.
State, do you have any objections?
Your Worship, we were hoping to finalise at least the arguments today. That does now not seem possible. I am not available tomorrow. The remainder of the week I am. Unfortunately, I have a matter in the High Court. But it seems the first available date of all parties is Friday, but this has not been canvassed with applicant number 2's legal representative. They were busy preparing their reply during the adjournment, so he's only walked in now. They are not aware of anything. Oh, I see. Advocate Riley is before court. So I think they'll need to be given an opportunity to address.
Good afternoon, Worship. Your Worship, we were advised during the lunch break that it was the intention of the first accused to do so. We have, during the intermission, compiled a replying affidavit which we believe deals with the issues. We don't understand why the first accused couldn't do that, but that's purely in the hands of the first accused. We are ready to proceed and to finalize the matter today. The affidavit is being commissioned as we speak. We do have an unsigned copy for my learned friend and for the court. We're ready to proceed. We don't believe the matter needs a postponement. The issues that the state have brought up, I don't think there's anything there that requires more attention than what the period that we've had so far.
When is your next available date, Advocate Riley?
I'm happy with Friday, Your Worship, but as I said, we'd rather deal with it today, but Friday my attorney and I are available. But as I said, we believe it's unnecessary, Your Worship.
That is,
Thank you, Your Worship.
Advocate Creel, I'm going to grant you your request for a postponement in the matter,
Yes, please, Your Worship.
but the matter is going to proceed on Friday.
Yes,
So
please, Your Worship.
kindly ensure all your replying affidavits or whatever you need to do is filed timelessly, and you are ready. The other party is ready to proceed in the matter.
Yes, please. Thank you, Your Worship, very much.
What is Friday's date?
It's the 7th of February.
Replying affidavits and arguments?
Your Worship, I will, as soon as we can actually get it back to the client who is in custody, have it, make sure that it's in terms of his instructions. I'll forward it to my learned colleague, and we'll be ready to argue on Friday as well.
I will request, Your Worship, that they do that by no later than Thursday morning, which will also give me an opportunity to peruse it and to prepare anything if needs be.
Are your filing heads of
That
arguments?
should be suitable. Thank you, Your Worship.
Are your filing heads of arguments? Oh, you give me a time. How long will your argument be? Then I would know.
I do not believe the arguments will be that lengthy, but my case law and my argument as far as it will go, I'll make the case law available to Your Worship. It will not be formal heads of arguments.
Yes.
But I will make everything that I use in my argument available to Your Worship so that you can follow the proceedings.
Advocate Riley, how long will your arguments be?
I don't think arguments will be very long, Your Worship. We're happy to file heads. Once we get the first accused, then we know where we are.
It's totally your decision, as long
Your
as...
Worship, if we could, if I think the state here, we can get some form of timeline. I think it would be beneficial to everybody, including the court and the state, is to prepare. So my suggestion would be to file the replying affidavit by Thursday, say 10 o'clock. We will file at the same time.
That will be the 6th.
And then you worship any heads of argument worship by 4 o'clock on Thursday.
The only problem that I do have with that and why I would choose to go with a more informal manner is that we do not know how my learned colleague will respond to our further paper, so it will have to be finalised on Friday after we're aware of everything that's happening.
I just don't want our heads of arguments to go longer than a bail application.
No, Your
And
Worship, no.
it's not, yes.
No. There are certain specific aspects. I'll refer Your Worship to case law. But beyond those, it will be the norm. This is a normal Schedule 5, and that will be the argument at the end of the day.
Very well then. Okay. Accused 1 and 2, or applicant 1 and 2, granted the postponement. Matters postponed to the 7th of February back to this court. It is for replying affidavits to be filed by Thursday, the 6th of February at 10 o'clock. You will both remain in custody. Thank you.
As the court pleases, Your Worship.
That's what please, Your Worship.
As it pleases the court, Your Worship.
I believe that then concludes this court's role as well.
I'm saying Friday works. There's no bigger on Friday, so you can start soon.
Beauty. Do you need the charge sheet? And then there's the annexures attached to it. Very well then. Hold your joints.
As a
Beauty, I have the code book. I'll give it to you just now. Do you need it?
I'll post the message on this. Do you want to
No, I need the information. I'm just going to drop it.
No, easy.
So now it's 2